So the idea that you have certain rights is something that people thought that you had, and really the Declaration of Independence came about and the whole Revolutionary War came about because people in this country in those days thought that they had the same rights that Englishmen had. In fact, the charters that were given to each of the colonies said that you have the rights of Englishmen. The rights of Englishmen are the rights of the Magna Carta, the rights of the English Declaration of Human Rights, but in the end, when the Parliament and King George said, well, we're not honoring those rights, you're different, you really don't have the same rights, despite what those charters would say, you have the rights that we give you because you are owned by us. That's what really led to the revolution, because the rights that people thought they had in this country, again, right to trial by jury, right to proportionate crime for punishment for a crime, a right to habeas corpus, those rights were being denied by the British. And so it was the feeling that you had certain rights that you weren't getting. Okay, so Jefferson writes this, says we have certain rights. When the Constitution is being drafted, why wouldn't you put in the Constitution that we have these rights? Because it was generally viewed at the time that if you have a specific rights enumerated in the Constitution, that in effect means that all the rights that are not enumerated you don't have. And they didn't want to actually exclude any rights. Secondly, many of the people said, wait a second, the states have given us rights. We have the rights to our states. We're really citizens of our states, and we have certain rights in our constitutions, and as we're now drafting our state constitutions, we're putting them in there. Why do we need to have it in the federal constitution? And some members said, wait a second, if you start talking about rights, everybody gets around to this everybody's treated equal kind of thing, and we don't want that because that's going to deal with slavery. And we don't want to really fool around with the idea that everybody's equal, because every time you have descriptions of rights, inevitably it gets to that everybody's equal, and a lot of the Southern delegates to the Constitutional Convention didn't want to do it. Interestingly, the rights that people focused on in the Bill of Rights were really rights that were designed to give people protections against government action that would be taking away liberties. Later, the Bill of Rights became more a document that defended people not so much when government was overall doing the people, but defending the rights of minorities and people who didn't have the protections of the majority. And that's really what the Bill of Rights has become more of in recent years. It protects people that don't have the wealth or the great power, and it gives them certain protections.
One of the things we assign to the courts is a reading of plain English in an unplain way, in a way designed to protect against what it would mean if you could really charge people not in the government. We're not even talking now about people who owe a duty to the government because they're government employees. We're talking about people, ordinary citizens, newspapers, whatever. But the task of the court, one of the hard tasks and very controversial when it's carried out, is how much to narrow it. I mean, what should they make of the fact that in 1918 there was a congressman that wanted to say in the Espionage Act, this applies to the press, and that didn't pass. So does that mean that it doesn't apply to the press? Or does it simply mean they didn't pass a law with the additional language in it saying that it did apply to the press? That's the sort of thing that the Supreme Court addresses all the time. Well, first, I've always been very, very dubious about the appearance of corruption being an appropriate basis to limit what would otherwise be First Amendment rights. I think it's one thing to say corruption, we're allowed to do things. You're allowed to take steps, you ought to take steps as a government to limit corruption. But when we're talking about the appearance of corruption being a sufficient interest to sort of trump the right to speak out or try to affect who's elected, I've never bought into that. I was in Ohio on a case unrelated to any of this the week before the last election. For me, it was like a First Amendment paradise. Put on television, all there are ads. Now, if I lived in Ohio, like the people of Ohio, I can understand driving you crazy with the amount of ads and the repetition of them, the similarity of them, and the unfairness of many of them. But all of that is the stuff the First Amendment's always protected. I mean, advocacy of who to vote for president. I mean, to me, that's sort of the heart of what the First Amendment is most about. People trying to persuade you who to vote for.
We know that the 1689 English Declaration of Rights secured the right to arms. James Madison referenced that in introducing the Bill of Rights and in introducing the Second Amendment on the floor of the Congress. It was well understood by English courts well before the American Revolution that people did in fact enjoy a right to have guns for the defense of themselves and of their families. Many state constitutions, either just before the ratification of the Bill of Rights or just after, memorialized a right to keep and bear arms that cannot in any sense be tied down to any militia duty. And it would have been perfectly understood by the framers that the right didn't depend upon service in the militia. After all, the words right of the people is found in the First Amendment, it's found in the Fourth Amendment. The people are understood to have rights in the Ninth Amendment. The people are not the states. The 10th Amendment shows us that those are different concepts.
All the evidence leans very heavily on the idea that they were looking for a check on federal power. Pennsylvania is an interesting example. So Pennsylvania was the one state that did not have a militia. Pennsylvania then as now was split between Philadelphia with its cosmopolitan elite of Quakers and the rest of the state, the backwoodsmen. And they fought a lot about whether they were allowed to have a militia or not. And part of the answer was that their state constitution said you can have weapons if you want them for yourself or to protect the state, but it wasn't part of a militia. And I noted in the book that Barack Obama was not the first urban politician to complain about rural Pennsylvanians clinging to guns and religion. It's remarkable how some of these same cultural divides go back that far. The framers were aware of that provision, and they chose not to include it. What they chose to include in the Second Amendment was starting with talking about the well-regulated militia, and James Madison's original proposal actually had a conscientious objector provision, saying that if you had religious scruples about bearing arms, you didn't have to do your military service in person. And of the 12 members of the House of Representatives who spoke in the debate about the Second Amendment, all 12 discussed the militia and actually this conscientious objector provision, whether that would weaken the militia. So it is striking when you look at whatever the miasma of general sentiment there was, what they thought they were putting in at the time.
And while 200 plus years ago was a different place in time, I think there's a fair, rough analogy that is worth pausing to ask ourselves about, which is the writs of assistant and general warrants that gave rise to the Fourth Amendment. The general warrants were a practice in England that when the police conducted an arrest, they often had a warrant with them that allowed them to rummage through the person's entire house, file cabinets, drawers, closets, and the like. In the colonies, the writs of assistance were a stateside version of that same practice, and that was one of, there isn't very often you can say this in the Supreme Court, but it was actually one of the core rallying cries for the Constitution and for the Revolution. The fact that the utter disdain for the fact that even if somebody is arrested or done something wrong, that is not an occasion to conduct an entire search of all of their private papers and most private possessions, which of course in the colonial times would have been held in your home or your office or the like. Now, with the advent of new technology, I think we have to ask the question, how do we protect that same privacy that the framers of the Constitution fought so hard to safeguard?
The fundamental vice of the writs of assistance and the general warrants was that they were issued based on the say-so of a king's officer, but without any requirement for particularized suspicion. And so the vice was that you were sending officers out to root through somebody's house to look to see whether you could find evidence of any crime, something that you then might use to arrest and convict them. This is a fundamentally different situation where somebody is arrested for on suspicion of a particular crime, and then the question is, what can you do with objects that are found or information that is found on the person. So you're already in a completely different world from the writs of assistance, because you're talking about somebody who has been validly arrested for a particular crime.